Hi, I'm Mike Marino, the third generation Marino to help students prepare for and pass the bar exam, and I'm back with another 5-minute tip. Hello, everyone. Let's talk about a critical topic that I get asked about as much as any other topic on the bar exam: strict liability. Now, this legal doctrine is a game changer because it imposes liability without fault. The key takeaway is the defendant's intent or negligence is irrelevant. If the conditions are met, liability sticks. So, what is strict liability? Strict liability applies in situations where the law decides the risk is so significant that responsibility must follow. A common example would include keeping inherently dangerous animals. We're not talking about dogs and cats, but tigers and wolves, right? Engaging in abnormally dangerous activities, hazardous activity like using explosives. And most relevant to our discussion and for the bar exam purposes, defective products, and that will be under strict products liability. So, what is strict products liability? The core elements to establish a strict products liability claim, a plaintiff has to prove 5 key elements, okay? And think of it as answering 5 yes or no questions, okay? The first question is the seller a commercial supplier? This applies to manufacturers, wholesalers, retailers, and even component part makers. This is not a Facebook transaction. This is a commercial supplier. The second question, does the product reach the consumer without substantial change? If it's altered after the sale, the liability may shift from the manufacturer to the person making the alterations. 3, was the product defective, making it unreasonably dangerous? And when we say defective, there's 3 types that you have to keep in mind. You have design defects, like an SUV that's prone to making rollovers and crashes. You have manufacturing defects. That would be like an airbag that's faulty and doesn't do the job. Or 3, an inadequate warning, which I'll give you an example in a moment, but think of it as like a poorly labeled toy gun, right? Fourth question you have to answer yes to is, did the defect cause physical harm? Like in negligence, though this is not negligence, you still need the harm. You need damages, right? Liability requires that direct link between the defect and the injury. And then finally, was the harm caused by foreseeable use? All right, misuse of the product can still lead to strict liability, but it has to be foreseeable use, okay? So let me give you some examples in how you'll see it on the bar exam, and then we'll get to some defenses that you also will see, but so that you're familiar with them. So an example of a strict products liability would be, think of a screwdriver. We all know screwdrivers are meant for screwing in screws, right? But people often do use them to pry open cans, whether it's a paint can or a soda can. That is a foreseeable misuse. Now, if the screwdriver breaks during that kind of use and injures someone's eye, let's say, well, the manufacturer could be liable for failing to warn users or for poorly designing it safely for that common misuse, okay? Let me give you an example actually from a recent bar exam as well that we can refine this concept with, right? There was a 10-year-old boy receives a toy gun for Christmas, and it has a hidden warning on it. And the hidden warning says, do not shoot near the face. However, the box's front shows a cowboy pointing the gun confidently. And the child ignores the warning or never even sees the warning and shoots near his face and punctures his eardrum. Is the company liable in this situation? Yeah. Why? Okay, why? Well, 1, the warning wasn't conspicuous, right? If there is a warning, it has to be big and blaring, right, and not small. And 2, the box created a misleading expectation of safety, okay? So keep in mind these examples, real-world examples that you could see on a bar exam. Do we have defenses? Yeah, we do, and they're the same as pretty much the same defenses as in negligence or other areas of the law. We have assumption of risk. If the consumer knowingly and unreasonably uses a product despite the clear risks, the defense will apply. Unforeseeable misuse, and I'm not talking about foreseeable misuse, but unforeseeable misuse. If someone uses a product in a truly bizarre way, it has to be way different. Not a screwdriver being used to a can, but a screwdriver being used as like a Q-tip, right? The manufacturer in that case may escape liability. Failure to follow instructions. When clear warnings are ignored by the consumer, it can shield the company. And finally, product alteration. That's significant changes to the product after sale can break the chain of liability. Keep in mind that, though, the unforeseeable versus foreseeable misuse, a great example from the bar exam of that product alteration is a paper cutter. You know, those big paper cutters that go down like this? They all come with a safety guard. The problem with the safety guard is it only allows you to cut maybe 3 or 4 sheets at a time. Well, people often would remove the safety so they can get 50 sheets at once. The company knew this, so they made the safety guard easier to remove. And while that is a product alteration, removing the safety of it and someone getting hurt by chopping off a finger or something, again, unforeseeable misuse, product alteration, it all has to be unforeseeable, not foreseeable. Though, unlike negligence, when we talk about defenses, contributory negligence, unlike in a negligence claim, a plaintiff's carelessness won't bar recovery under strict liability. This is not negligence. This is strict products liability. So contributory negligence is not a defense. And the second one to remember is reasonable care by the manufacturer. Even the most careful company, no matter how careful they are, you're still going to be liable if the product is defective. Again, this is to protect consumers. It is without fault. This is not an intentional tort. This is not negligence. This is certainly not a crime. This is strict products liability. The facts will lead you to that. So issue spotting should be real nice and easy. Don't stress, however, if you get a strict products liability question and you answer with a negligence analysis, so long as you use your deductive reasoning skills and analyze the question fully, you'll still score points on an essay. All right, but let's keep in mind that strict liability is not negligence. So to wrap all of this up, strict liability ensures that manufacturers bear the cost of dangerous products, not consumers. It's a doctrine of fairness. It's designed to incentivize safer products and to protect the public. Remember, fault doesn't matter, but the elements and defenses do. Nail those on the exam, and you're golden.